Hello, everyone. I'm Kira Phillips. Our top story this hour, former President Donald Trump will not go to trial next month in the Georgia election interference case. The Fulton County judge ruling the 17 defendants, including the former president, will not be tried on October 23rd alongside speedy trial defendants Kenneth Chesebro and Sidney Powell. The judge says separating the case is absolutely necessary and even laid out a number of his logistical concerns. Joining us now, investigative reporter and producer Olivia Rubin, there in Atlanta, also contributor and law professor at the University of Baltimore School of Law, Kim Wehle. Olivia, let's start with you. What does this mean now going forward, specifically with Trump?
Well, first and foremost, Kira, there are now officially going to be multiple trials in the Fulton County election interference case. We know that there is going to be one trial for Kenneth Chesebro and Sidney Powell. They will start on October 23rd. But Trump and the other 17 defendants, Kira, are now pushed down the line. We don't know exactly when that trial will be. We do not have a date. But really key here, Kira, is that the judge, in his motion breaking up this case, did not eliminate the possibility that he could further sever down the line. So we have one severance so far. We know there will be two defendants on trial, as I just said, the other 17 down the line. But the judge said there very well may be the need to sever once again and break it up. So as of now, two trials at the minimum, Kira, with the possibility that there could be more. And prosecutors have said, regardless of how many trials, regardless of how many defendants, they need 4 months minimum for each and every trial. So as of now, at least 8 months worth of trial, and that's just on the prosecutor's side, Kira.
So, Kim, what are the logistical concerns that the judge could be talking about here?
The judge is worried. He mentioned that the courthouse just might not be large enough for all 19 defendants, their lawyers, and just so the logistics around that level of trial. But in terms of the constitutional rights of the other parties that are not being forced, that are severed, that is Donald Trump and the others, I think it's inevitable that this is the ruling in part because it's a pretty complex case and trial's really around the corner. So I don't see any other feasible option, frankly, than what the court did in terms of setting forth multiple trials, at least two moving forward.
So, Olivia, you spoke with the attorney actually for Kenneth Chesebro. What is he telling you?
Well, we spoke with Kenneth Chesebro's attorney right after court, and just a reminder, Kira, that is the defendant who is set to go to trial in just 39 days. I think we have here what he said to us outside of court.
October 23rd can't come fast enough. Mr. Chesebro is not a politician. Mr. Chesebro is a lawyer. Mr. Chesebro is an attorney who had a specific job to advise the Trump campaign on certain very obscure areas of the law, and that's what he did. Our client is entitled to a speedy trial. Our client's going to get a speedy trial, and we're not going to be the ones to try to delay that.
So you heard there, Kira, sort of a defense starting to emerge from this defendant, Kenneth Chesebro, who was the attorney for the Trump campaign in the wake of the 2020 election. And that has been the argument we have heard from him, is that he was doing legal activity, advising his client, Donald Trump, in the Trump campaign in the days after the 2020 election, and claiming that there was nothing illegal about it. Of course, prosecutors say it was part of this overarching conspiracy to overturn the results of the 2020 election. But a bit of sort of a sneak peek, Kira, into what we could see from this defendant, who will be the first to go to trial in this sweeping case here, and what other defendants will be watching to really get a preview what the trial is going to look like and what they could be then facing down the line.
So, Kim, did you expect this to happen just with the amount of defendants in this case? I mean, we sort of knew it would be a bit crazy and a lot of changes would be made.
Right. So it's possible that additional defendants will join and have this more rapid trial. It's the right to a speedy trial belongs to each defendant. It's grounded in the Sixth Amendment to the United States Constitution and then implemented under Georgia law, which is why we have the deadline looming under Georgia law. But it's essentially up to each of those defendants and their lawyers to decide whether to waive it. And it looks like, at least for these two defendants, they thought the strategy is better to just forge ahead as quickly as possible. But as Olivia indicates, for people like Donald Trump and the others, they're going to get a preview of the government's case. And it's also possible some of the witnesses the government will call will have to testify a second time. And there's always going to be a concern for the government that there could be some inconsistencies in that testimony. We all, we're not computers. We don't say the same thing over and over again. So, but, this is complicated in part because Fani Willis decided to bring such a sprawling, complex case, really different from what Jack Smith decided to do with 4 discrete counts, all unindicted co-conspirators in Washington, D.C., in the federal case relating to January 6th. So we see multiple different strategies, both by prosecutors and defense lawyers moving forward in these cases.
Olivia Rubin, Kim Wehle, thank you so much.
Hi, everyone. George Stephanopoulos here. Thanks for checking out the ABC News YouTube channel. If you'd like to get more videos, show highlights, and watch live event coverage, click on the right over here to subscribe to our channel. And don't forget to download the ABC News app for breaking news alerts. Thanks for watching.